Welcome to the second episode of the NALA Talks Microlearning series presented by the Diversity, Equity, and Inclusion, or DEI Committee of NALA. My name is Terry Walters, and I am the chair of the DEI Committee. The DEI Committee works to address diversity, equity, and inclusion, to foster meaningful, open, and constructive dialogues throughout NALA, and to celebrate diversity of its members and leaders. Joining me today are NALA's DEI Committee members, Angela Overly, Candace Russell, and Christine Custodio-Suero. Today's conversation will focus on name, likeness, and image with Jeremy Evans, Esquire. I'd like to take a moment to turn over to Candace, who will be introducing Jeremy.
Hello, everyone. Today we have Jeremy Evans with us. He is an award-winning attorney and industry leader based in LA and Newport Beach, California. Mr. Evans is an expert in best practices and negotiations in entertainment, media, and sports. He represents entertainment, media, and sports clients in contractual and IP negotiations with a focus on deal-making. His clients range from Fortune 500 corporations to entrepreneurs, advertising and production companies, studios, agencies, talent, and more. Mr. Evans is a CEO, founder, and managing attorney of California Sports Lawyer. He writes a weekly column and hosts the California Sports Lawyer podcast on the Believe Network, which focuses on the latest topics and most interesting legal angles in entertainment, media, and sports law. Within the community, Mr. Evans has previously served as president of the California Lawyers Association, which is one of the largest voluntary bar associations in the world. And he currently serves as president of the California Lawyers Foundation, which is the nonprofit arm of the California Lawyers Association, and as chair of the CLA's task force on artificial intelligence. He is also a member of the board of advisors for the Rose Bowl Legacy Foundation, a sentinel campaign for the Rose Bowl Stadium. He serves as an advisor to entrepreneurs in entertainment, media, and sports for the U.S. Small Business Administration, and is a member of the Faculty of Law at the California State University of Long Beach graduate program in sport management. Welcome, Jeremy.
Thanks for having me. Honored to be with you.
Could you tell us a little bit about your background and how you got involved with name, image, and likeness matters?
Sure. Again, a pleasure to be with you. My background in this is really by nature of the fact that I've been involved in sports and entertainment for a little over the last decade and pursued that right out of law school. It was something that I really wanted to do. Out of all the other legal practices and areas of practice, that just made the most sense for me. I thought if I'm going to put the time and energy into building a business, then I'm going to do it in the areas that I like, which was entertainment and sports. I had done some acting as a kid in some plays and played sports as a kid, baseball into high school, and really just enjoyed sports entertainment. And so when I opened my own practice, I obviously had an interest in college sports and professional sports and in the entertainment business, particularly in Hollywood and with some of the unions. And so I think it was sort of a situation where that was just where things were going in terms of name, image, and likeness was introduced through the Fair Pay to Play Act in California, which kind of launched a national discussion and other states began to follow. And then, of course, that just delved into the ability of, talking about the subject and being available to talk about the subject and becoming familiar with what was going on. And that's really how it started and where it's at now.
Just so that everybody knows what NIL means, it's name, image, and likeness. What exactly is that?
Awesome. So great question. NIL, name, image, and likeness, it's an acronym for it. And what it really is the ability to make profit off of who you are. It's to make profit off of your nature, your ability to be a person, right? So this is something that has been codified in the laws for years. In California, I think it actually goes back to 1976, where somebody could have the ability to either sell their image or make money off of it. There's case law that goes back many years over this. But it was more recently codified in the name, image, and likeness law, specifically the Fair Pay to Play Act, which went into effect on July 1st of 2021, was really a way for college athletes to do it. Up until that point, you had the NCAA, which was restricting college athletes from being able to make money off their name, image, and likeness because it was in an educational setting. And so ultimately, this law opened the books for that and allowed for that once the NCAA changed its policy. In other words, even if this law was passed, which it was, if the NCAA did not change its policy on athletes making money off their name, image, and likeness, then there would have never have been the ability for college athletes to do that, as long as they wanted to obviously stay in collegiate sports. So since that changed, the entire model has changed, and now there's an entire national discussion going on through the House settlement and other matters that is talking about what this structure should look like.
And does the name, image, and likeness apply to all universities and colleges, or just the ones in the NCAA?
So the California law was pretty much for everybody, and even high school athletes, obviously depending on certain rules and restrictions. But in general, California opens it up. Other state laws somewhat limit it, and there's been some Supreme Court talk about this, but it's unrelated. The Alston case, which was a 9-0 decision written by Justice Kavanaugh, was talking about student benefits as looking at scholarships, educational benefits, that sort of thing. It was not talking about NIL. NIL has been talked about in a couple other district court cases and even in the Court of Appeals, particularly through Justice Claudia Wilken here in California, where she looked at the O'Bannon case and is clearly now looking at the House settlement. All those things have to do whether an athlete can make money off their name, image, and likeness, and it's in particular focus to college, although it could be in high school. And as far as whether it applies, it just depends on each individual state law, and of course the different conferences. Pac-12, well, not Pac-12 anymore. Now it's gone, but or it may be trying to resurrect itself, but Big Ten, SEC, ACC, Big 12, and that's what the discussion is about, is what those rules and regulations should look like. Your question is very interesting because does it apply to everybody? Absolutely. But the problem is, can you make money? So NIL is market-based. It's what a company is willing to pay you to promote a product, endorse a product, put something on social media. Generally, this comes in three categories. Either you're getting paid directly, number one, you're getting product, or you're getting ownership or some percentage in a company. Sometimes it's all three, sometimes it's a mixture of those three. But you have to be a marketable athlete to be able to garner and or demand that sort of money, right? Now, part of this national discussion is, should universities be able to pay these athletes directly, and what should that look like? And of course, the House settlement is looking at splitting basically $20 to $22 million amongst these Division I universities, whoever wants to participate in this. And it says, if you make so much money per year as a university, you can then split those dollars amongst your athletes. But of course, this raises questions for Title IX with regard to having no sex discrimination in college athletics. And if you're paying the starting quarterback versus the starting volleyball player or softball player different money, that creates some potential issues. But then again, on the other hand, if the starting quarterback is getting paid more money versus somebody else, that potentially creates some issues. I personally think that the best model going forward would be something that's market based. Allow the market to decide how much an athlete should be paid based on their name, image, and likeness rights.
Very interesting. Angela, did you have any questions?
Can students use like their school uniforms or school logos in their name, image, and likeness?
Really great question. And so generally, and this is actually came as a surprise to me when the schools did this, for the most part, schools have decided to allow athletes to use some of the branding. There has to be an approval process. And that's partially why the universities wanted to get involved, to be able to have more compliance over some of that. But in general, the universities are allowing some coverage of that. But there's limitations there, and there's approval processes.
Hi, Jeremy. I have a question for you. Thanks for sharing this important information. Some of our folks in NALA may not know about this, or have a lot of interaction with name, image, and likeness in the NCAA. And I was wondering if you could just give a little bit more background on maybe like how this works. How does the school engage? How does the NCAA engage in this type of relationship with name, image, and likeness and their student athletes?
So great question, and I appreciate it. I think that what's been happening, let me start with this, where it started and where it's at now and where it's potentially going. So where it started and the intent of the Fair Pay to Play Act in California, and then other states began to follow. And when California passed that legislation, it put pressure on then NCAA president Mark Emmert to change the policy, because he saw the national conversation changing. There was a lot of pressure, potential for litigation. He relented and said, let's change the policy and let's allow athletes to make money off their name, image, and likeness. So that then turned into universities competing over athletes in recruiting and sort of using NIL to help garner that discussion. Now, there's some rules and responsibilities around that. Generally, you're not allowed to use NIL money to, guarantee something and say, we'll pay you $3 million if you come here. But they were able to give a valuation and say, this is the potential we could bring you, right? And universities began to get more involved. And it wasn't just athletes brokering private deals. It was universities basically saying, let's bring this together and let's help broker this and let's add compliance to this and that sort of thing. So that's where it's at now. Where it's going is, yes, there's contracts currently, but some of the discussion is around how this plays with the transfer portal, where currently there's no limitations on that. And these are some of the new rules that have come out. But there's thoughts around this idea that, and actually Lee Steinberg and I have authored a piece that is going to be coming out in the LA Lawyer magazine, which is going to talk about some of these issues. And the thought is that if you accept money from the university, you should have an obligation to that university for a period of time. No different than you're signing a contract to do work for somebody. If you're in that contract, you should be, basically set up to have to stay with that team. And of course, you could negotiate a 1-year deal, but maybe that means you're taking less money. And so my thought here is that, or our thoughts in this article, is that there should be some continuity there. It's very difficult when you start getting into a numbers game where you have universities, and this was proven in the recent March Madness tournament for men's basketball, was that you had only top universities in the Final Four. There was very few Cinderella teams, and that's because a lot of the players at the non-blue chip schools or what you would say Cinderella teams that are not in the big sort of the Big Four, Power Four conferences, that they were not making it further in the tournament because a lot of their players had transferred to these bigger schools for more money. And so the idea is that, hey, if you're going to get paid money, you should commit to that school, just as the school is committing to bringing money to you. So that's where it's potentially going. Ideally, I think that where this would be best is that the schools were not involved. Again, I think that this needs to be a market-based approach. I think the second the schools get involved, it becomes a professional association. It's no longer college. By the way, it's very difficult to form a union in general, but imagine trying to form a union when your average career of a college athlete is 1 to 3 years. Very difficult. It's not like you're an actor acting for 50 years, 40 years. Even professional athletes, you're talking about the average career for professional athlete is 3 years, but that's something to work with. And most of the athletes, last longer and you have longer careers. So you can have a union and you can be able to negotiate contracts and reach free agency. You're never going to reach free agency in college sports unless you consider that it's 1-to-1, 1 year deal, 1 year deal, 1 year deal. So that's where it's at, and that's where it's potentially going.
Thank you so much for sharing that. That's interesting. And that resource that you had mentioned earlier, is that available for us to consume now online to read, or is that something that we can make available to our readers? That would be very interesting to read that piece that you wrote.
Thanks. Yeah, I'm not sure when it's coming out. It's supposed to be May, June, but I don't know the exact release date, but it'll be done online.
Okay, we'll look out for that. And, kind of shifting the conversation, because I do appreciate this, these points that you're bringing up, especially as an attorney, and our paralegal audience may have interest in this as well, because there are going to be risks and implications, tax and otherwise, for these athletes, entering into these kind of name, image, likeness deals. And, there are things to consider for even from the athlete's perspective, such as, should I set up an LLC or some other business entity, because now there's potentiality for these high income earning. But from your perspective as a lawyer, do you see that there are maybe common mistakes, especially you forecasting, like, where is this going, with regard to athletes, with regard to, college athletics? Are there any common mistakes that you see from athletes or even brands in these kinds of deals or transactions?
Well, I think there is. I think one of the concerns is that, the idea for NIL was that athletes would have an avenue to create monetary opportunities for themselves. And they would do that independently of the school. Now it looks like the schools are taking over that and they're being trained in NIL and they're using it as a recruiting tool. I don't think that's correct. I think that this needs to be an independent market-based activity, which avoids Title IX issues and avoids unionization issues and avoids employee classification issues for employee versus independent contractor and all those other issues. I think it adds for more parity when you're talking about if you have a small market team that is looking, or university that is looking to recruit a major athlete, and if they said, hey, we can give you more dollars, then allow the market to decide that. Allow the market to pay him for going to a certain school, right? As opposed to giving the universities the money to pay more to certain athletes, right? I think that decreases parity and competition amongst the teams, right? So I think that's where it's going. Those are some of the issues that are sort of coming with NIL, and we'll see what happens.
Great, thank you so much for that information. And I want to pass it over to Candace or to Terry if they have additional questions for you as well.
I do have a couple questions actually. You did touch upon a little bit about rules and regulations. What happens when they violate these rules? I mean, you're getting these kids, 18-year-olds even, 17 even, to sign these contracts. What happens if they default on a contract or decide they don't want to stay at that school anymore? They can't hack it. They want to go to a different school. Do they get sued? And then the second part of that question is, are they required to file taxes on this income? Because I do know when you're working and you're in school, usually you don't have to pay taxes. So how does that work for the NIL?
It is 100% taxable. A lot of these athletes are filing LLCs and doing loan out corporations where you're getting paid through your LLC, so you have a lower tax rate. They are absolutely taxable, and it's definitely a big part of the NIL scheme and program, and part of what agents and lawyers and accountants are doing for some of these athletes. As far as contracts go, has there been any lawsuits, so to speak, so far? Not so much. I think teams have been weary, or colleges have been weary of utilizing the litigation process to go after college athletes. I think this is best displayed by some recent comments of some major head coaches for college basketball, talking about the fact that they no longer bring freshmen in. They're bringing in transfer students. And it's because there's a higher level of maturity, there's a higher level of experience, and you don't have to do a lot of that sort of recruiting piece. You can basically, you can do the recruiting piece, but you're not doing it from like a freshman standpoint. It's like the person already has experience. And so that's where we're kind of seeing the model change. But again, I don't think we've seen schools that have tried to implement litigation or challenging student decisions when they want to transfer, or not relying or not staying after they've been paid. I think at the end of the day, for the most part, that the schools are taking a risk because just as much as they might lose a player, they gain another player. Very important how they play together, the transfer portal and NIL, and they're frankly being used together in a model that I think needs to be fixed and monitored. The NCAA, I think, unfortunately, has been somewhat quiet on this, and more recently, they've now talked about creating a thing called the College Sports Commission, or CSC, and this would be an independent body that would review NIL contracts and go through that. I frankly think it's a mistake for the NCAA to remove its authority in this.
Why?
I think ultimately the NCAA is the governing body. And this would be like saying if you and I wanted to go play golf and join a country club, we have to follow the rules of that country club to play there. And so if you want to be a member institution of the NCAA, you need to follow the rules. So for the NCAA to remove its authority, I think is potentially a mistake. Now, look, could it work out? I'm an entrepreneur. I get it. You try new things. Great. I wish them all the best. I hope the model succeeds. But I think to have an independent body is probably not the best idea. And I think for the reasons I said. And I think secondly, when you have this CSC, it creates this sort of now separate entity. And I think when people brought in Charlie Baker, the former governor of Massachusetts, I think the idea was that he was going to bring in more regulation and more oversight into this and bring more stability, which a lot of the coaches and even the players are calling for. I think trying to go through Congress is not the right approach. And not because Congress takes a long time. Congress is supposed to take a long time. That's the whole point of checks and balances. I think the point is that Congress is not meant to meddle in state law. They're meant to meddle in federal issues. And a sports conference is not a federal issue. And ultimately, look at the history of these things. Congress has rarely gotten involved in terms of passing federal laws. This is why you have, agent laws that are different state by state. Conferences are in different states. So again, I think I hope it works out, but I would have preferred that two things: NIL be dealt with from a market-based standpoint, and that the NCAA deal with regulation so there's a nationwide standard, but not from a federal law standpoint.
I understand your point, but aren't these schools playing across state lines? That's
They
what the
are.
part of NCAA is. I mean, New York is playing against
Right.
Indiana, Florida is playing against Texas. I mean, that's the whole thing about the March Madness. All these states, all these different schools from different states are playing across state lines against each other.
Mhm.
So in a sense, wouldn't there be some sort of federal regulation? Just a question.
Right. No, I welcome it. Here's the thing. 100% understand and respect, your point and the question. And I'm not the answer to all of this, right? I'm just offering an opinion. And what I would say is this: never in the history that I can recall has there been a federal law that has dealt directly with either NCAA sports or even professional sports. What you've had is litigation that's driven that. So antitrust violations, that sort of thing, right? To your point about interstate commerce, yes, you can make the argument that these conferences are in different states, these teams are in different states. My point I think we're what I'm trying to say, I think we're saying the same thing. I think there's just two ways to go about it. You can say, hey, Congress, let's pass a federal law. And I would say, I wish you all the best. It's not going to happen. On the other hand, I would say, why not go through the NCAA to create a national standard, have the schools agree to it, and I think go about it that way, because then you're dealing from a level playing field across the board. So I think, look, if a federal law can be passed, great, but I think that would be bad for a couple reasons. One is the unlikelihood of it happening, and then two, the ability to enforce that as a private entity, which the NCAA is, and which college sports are, and with in terms of, like, they might have public schools, private schools, right? But ultimately, these conferences are private entities; they're not public. And NCAA is a private entity. You would not want a federal regulation over you in that regard. Uh, it, you know, Professional sports don't have it; college sports should not have it. So that's my 2 cents.
Does that college sports commission, is that supposed to help protect the student athletes at all? Or is it just primarily for the schools?
There may be some oversight in that regard, but this is where, again, I think the NCAA regulations are just very important. And if you go conference by conference, I don't think that solves the problem that we were just talking about. If you go school by school, that makes it even worse. I hope it does, but I think those ideas are still being ironed out. So I'll leave it at that.
And my last question is, what should a student athlete and his or her parents, guardian look out for when they think they're going to be this star athlete in high school and be recruited by a college? What are some red flags they should look out for, and when should the light bulb go on saying, oh, I think we need to speak to a lawyer?
Yeah, really great question. What I would advise parents, and parents are beautiful in this way, that all parents think that their kids are God's gift to the world, right? Absolutely. But when it comes to athletes, right, you have certain athletes that will make it to the next level and certain ones that won't. And statistics prove that. You have a situation where, it's a less and less percentage as you continue to go from, T-ball to pony league to pee-wee football to high school to college to the pros to the Hall of Fame, right? That percentage of people continues to get smaller as it goes. So I think parents need to go into these situations with a protective mind, protect their kids, of course. But I think advocating is tough, right? At the end of the day, talent wins. If a student is talented, they will be seen. We live in an era where everything is online. There's ability for social media and video at almost every corner. And so being unseen is highly unlikely. Matter of fact, a lot of teams actually will recruit in areas where they don't have much visibility. They will specifically go there and look for opportunities, right? That doesn't mean that you shouldn't try and you shouldn't do this or that, but there's a proper way to go about it in terms of trying to get the attention of a coach or that sort of thing. And it's not screaming from the dugout, hey, play my kid, right? So that's the first thing. I think the second thing is that have a conversation with a lawyer or an agent. Doesn't cost anything. Most of these folks are willing to give you a free consultation and sort of see where that takes you. I think that's the best way to go about it. And then, of course, we also live in a day and age where information is readily available. So do your research. Talk to the university compliance department. Talk to lawyers, as I mentioned. Talk to agents. Talk to other athletes who have been through it. Talk to NCAA compliance folks. There's just so much availability for information on people out there. That's the approach that I would take.
Hey, thank you so much. Terry?
I have a few questions. Jeremy, thank you so far for all the questions that we're throwing at you. Purely financial. I played ball in college, and I know there's booster clubs, and they give you like a stipend to buy foods and stuff. How are the booster clubs affected nowadays with this, with all these negotiations and these students making money? And is there a limitation on what these students can accept as payment and funds? I mean, they can't get like $100,000 Rolex and a Porsche to drive around as part of their contract, or can they now? Previously, that was forbidden.
Well, I think this is where the College Sports Commission and NCAA rules and conference rules and however this House settlement comes about will help decipher some of this, right? So I think Wild West is not the answer. I think you need some semblance of, you need a free market, but you also need a baseline of what the rules and regulations are, right? So I think that's the first thing. As far as the boosters go, I think that's part of the question. That's part of the conversation, right? Where does this go? How are these collectives and boosters regulated, right? Because that's one of the pieces of both competition and fairness, is this idea that if one school has a large database of alumni that are willing to give and another school doesn't, part of that is competition. Okay, that school's done well. They should be rewarded for that. On the other side, let's deal from a sense of fairness or parity as to setting rules that sort of apply to everybody. So that would be my 2 cents.
Last question for me. Do they have access to these funds immediately, or do they have to wait until they turn 21 and 24 before they can start spending money?
Yeah, my understanding in California is there's no limitation. You have access to the funds immediately. I know some states have passed laws that their sort of NIL laws are somewhat restrictive, but I think generally you're getting paid immediately. And that would also be determined by the terms of the contract. Do you get paid all up front? It is a percentage, that sort of thing. But I think it's contract based, but I am not aware of restrictions as to they can't be paid. The one thing I would say, if they're under 18, it would likely go into what they call a Coogan account, which is specific to California, where if you're paid certain dollars, your parents have to put it into a Coogan account to set that aside. And this is basically done out of the fact that there was cases of situations in families in years past where you had families that would take in money, but then the talent, the son, the daughter, would not be receiving that money because the parents spent it or the family spent it.
Thank you.
How are the earnings and the deals documented, like for tax purposes? Do they get like 1099s or?
Yeah, 1099s, and you have the contract obviously showing that, bank statements or whatever, however they got paid. But yeah, it'd be typical, no different than any other business model. if you got paid, the company would be required to send you a 1099.
Okay. And what common mistakes do you see with the student athletes that they make when they're going over contracts?
Well, I think number one, it's such a good question. Number one would be people not doing their research on the particular company. Let's assume that it's a smaller company, not a large company, maybe up and coming. So there's a lot of upside, but then maybe not so much on knowledge or research of that particular company. So do your research, know what you're getting into. I think number two is understand the terms of the contract. What are your responsibilities? How many times do you have to post? What do you have to do to earn this money? I think there's this conversation going on as to the Fair Pay to Play Act was meant to be, if you do something, if you create something, if you post for us, you're exchanging your name, image, and likeness. We're licensing it so we can promote our product or service. You'll get paid. I think what it's morphed into is more, we're just paying you to be an athlete, right? And I think that's where the discussion is happening and what that pay to play will look like, or whether it should be called play to play, or whether it is pay to play. And so I think that's part of the discussion. But again, I think know who you're going into business with, understand the terms of the contract. Those are the two biggest things I think that I see. Plus, understand the FTC guidelines. Make sure that if you're posting something, you understand that, this is an advertisement. Make sure you have the proper disclosures. Make sure you have truth in advertising. Again, back to point one, don't promote a product that you don't know about. Even more so, don't promote a product you don't use. There's a sort of believability factor in advertising, right? For example, when Shaquille O'Neal did the Icy Hot commercials, he's a character. He's a funny guy. He's a really good guy, and people like him. So, and he was also older at the time when he was doing this, and he's a big guy, and he had knee issues, right? So that's believable. It made sense. It was a good advertisement. I think that is a good model for doing a product or a service endorsement. So I think that's kind of what we're seeing. I will also say too that some of this larger discussion with regard to NIL is again this point which I mentioned, which is it pay to play or is it NIL? Is it, you're promoting a product or service, or are you getting paid to play? And I think that's what the discussion is about, and where the discussion is likely headed and is headed.
So it appears that in choosing schools, you also have to make sure you have a counselor, a financial consultant, an attorney, and definitely have your parents by your side to make sure you're not taken advantage of.
Amen. That's exactly what it is.
Thank you very much, Jeremy, for taking the time to answer all of our questions and to shed more light on this name, image, likeliness, and how it relates to the NCAA and these students coming in nowadays. I wish we had this back in the days when I was playing.
Yeah, I hear you on that.
Thank you, Jeremy, for your time and expertise.
Thanks for the tough questions, Terry.
Thanks for being willing and able to answer each one of them. We really appreciate you. Want to have a special thanks to Candace Russell for leading this presentation, as well as Angela Oberle and Christine Studio Suerdo. Thank you, everyone, for your time. We have links below that will assist you in following Jeremy Evans, his podcast and his website on what he does is extraordinary. He's an extraordinary being, and he's a nice guy as well. We look forward to seeing you at our next NALA Talks episode.